morning's docket. Case number 111279, State of Kansas v. Cheeks.
May it please the court, appellant Jerome Cheeks appears by counsel Paul Dent. Your Honor, may I request 3 minutes of rebuttal time?
3 minutes is granted.
Thank you, Judge. What you have before you today is the appellant asking you to determine that a phrase, a person in state custody as set out in case A21-2512, is applicable to him and his request for post-conviction DNA testing. A quick recap of the chronology. Back in 1992, this individual's wife was beaten to death, murdered in Wyandotte County, Kansas. My client, Mr. Cheeks, was convicted at trial in August of 1993. He was sentenced to a life term, 15 years to life under the Kansas pre-1993 indeterminate sentencing statutes, 15 to life term. In March of 2009, he filed a motion under KSA 21-2512 asking the district court to order post-conviction DNA testing. That was denied by the court. He filed his notice of appeal, and we argued this case to this court in October of 2012. October of 2013, this court issues its decision reversing the district court, remanding, stating that in this particular instance, this individual did have the right to request that DNA testing if other prerequisites were met. Between the time that the case was argued in October 2012 and decision rendered in October of 2013, in May of 2013, Mr. Cheeks was granted parole after serving 20 years of his 15 to life imprisonment. Upon remand, the district court denied the motion, stating that the court determined that because Mr. Cheeks was on parole, he was not a person in state custody as set forth in that statute. Today, as I stand before you, Mr. Cheeks remains on parole. In effect, he has a life imprisonment sentence that he's still under. The district attorney...
Excuse me, counsel, he remains on parole in this case, but we've had some updated information that I understand you were copied on about he's actually in custody in Missouri now on something
Yes,
else,
ma'am.
and has a federal conviction or federal charge, or
What I know for certain is that the Kansas Department of Corrections has issued a warrant for him, apparently for failure to comply with his parole requirements.
Okay.
And I think his failure was that he was arrested in Missouri. I haven't confirmed the records, but Mr. Gorman tells me that he has pled guilty to a federal charge of weapons possession. I do know that he is currently in the Bates County, Missouri County Jail, perhaps being held on this federal charge and awaiting sentencing on that federal charge.
okay, thanks. Man.
So, but as far as I think for this court and this decision to be made on this case, he still remains in the custody of the state of Kansas. He still has a life imprisonment sentence. He's sitting under here in the state of Kansas, subject to being revoked and having to go serve that entire sentence. So, interpreting this statute, I think our rules of analysis state that we must look at the statute itself, and I'm happy to do that here. Because I think if you look at the statute 21-2512, it answers the question for us as to what does it mean, a person in state custody. Number one, if you look at the statute, you can see nowhere does it state that the person who files that petition for testing has to be in prison, has to be an inmate, has to be incarcerated, has to be a prisoner. It doesn't state that. It states a person in custody. It states that a person in state custody may petition at any time. Again, on the date that he petitioned, he was an inmate of the Kansas State Penitentiary. So there's no question at the time of filing he was an inmate and an imprisoned, incarcerated inmate as well. I don't think it matters though. I think he could have been, under the case law that I cited in my brief, he could have been on parole at that time and still filed this motion. Number 3, the phrase in custody is defined in our criminal procedure statutes. KSA 22-2202 subsection 9 defines custody. It states detained, confined, restrained of liberty. It doesn't state imprisoned, it doesn't state incarcerated, nothing like that. I've cited a long line of Kansas cases which involve habeas corpus cases. All of those cases focus on the phrase in custody. In those cases, and the district attorney has conceded this in his brief as well, all of those cases state that a person in custody includes someone who is on parole, who's on probation, or who is on bond. I will add that, again, in looking at the statute itself, I think it determines fully what we're here to talk about today. If you look at the statute itself, 21-2512, subsection F, capital letter B, II, it states what the district court may do if they do find in favor of the petitioner. It states that in that subsection, the court may discharge the petitioner if the petitioner is in custody. Now, there is no reason for the legislature to put that if in there unless they anticipated that someone who petitions for this might not be in custody when the court rules on it. So I think everything we need to decide this case is within that statute. I think the statute is clear. I don't think it's ambiguous at all. I think the legislature was well aware of this legislative history and the interpretation of the phrase in custody.
Counsel, may
Yes,
I
ma'am.
stop you just for a moment again? You cited a statute when you said the defined custody. Was that 2237-17 or was it something else?
22-2202,
Okay.
subsection 9.
Have you looked at 2237-17 on parole and probation?
I can't recall what that says if I have
Parole
to.
and post-release. It says that a person on parole remains in the custody of the Secretary of Corrections. Does that have any bearing on this, you think?
Obviously it uses the word in custody, so I think that reinforces what I'm stating to the court, that a person, when you have a life sentence, you continue under that for the rest of your life and you're subject to being revoked. The state doesn't have to go out and file any new charges or anything like that if on your parole you do something wrong. They can revoke it. I know that the district attorney has tried to differentiate the language from the habeas statutes because in 1501 it doesn't use the phrase person in state custody, that's 60-1501. 60-1507 it uses slightly different language as well. I think if anything, the language in those habeas statutes is even more restrictive than what the legislature chose to use in this post-conviction DNA testing statute. 60-1507, which many cases have stated means that someone on parole is still eligible under, states a prisoner in custody under sentence. It uses the word prisoner. It doesn't even use the word person. But even despite using the word prisoner, our case law says a person on parole still is eligible to file a 60-1507. And the fact that it says under sentence, the only reason that language was used in 1507 was to distinguish it from 1501 to make it clear that it is applicable for people who have been convicted, who want some post-conviction relief of what they've been convicted of, what their sentence is. So I think the language, although the district attorney wants to state that that language means that the legislature was trying to be more restrictive in this DNA testing statute, I think the exact opposite is true. Also, if you look at Rule 183, Supreme Court Rule 183, it uses the phrase, 1507 may be invoked only by a person in custody claiming the right to be released. Again, there's that phrase, in custody. As I pointed out in my brief, obviously almost every state in our country does have post-conviction DNA statutes. I found 2, Illinois and Washington State, where there was an interpretation of whether someone on parole or who at any rate was not incarcerated was still eligible to apply for the benefits of those statutes. And in both of those cases, it was determined that a person not incarcerated was still eligible to make application. Finally, I think the intent of the statute, when this was first passed, was to give people who had been convicted, but who hadn't at the time of their conviction had the opportunity to have DNA testing done. It gave those people the opportunity later, in certain restricted cases, it gave them the opportunity later to have an opportunity to show to the court that there is evidence under new, more updated scientific proofs that can be used to show that they should not have been convicted. So I think the legislative intent was to give someone who perhaps was wrongly convicted the opportunity to use modern scientific methods to obtain his freedom. And I can't imagine why the legislature would differentiate between someone who is in prison and someone who happened to be paroled the day before the judge makes a decision on this sort of issue. It just doesn't make any sense. So I do respectfully request that the court determine that in custody, as this court has said in many different instances, applies to someone who is on parole. And the fact that he's in a Missouri jail right now, again, that hasn't changed his Kansas status. He remains a person in custody subject to a life sentence in the state of Kansas. And in fact, there's a warrant right now for him. His future may involve going back to the state of Kansas penitentiary system.
Which would
So-
moot this issue. Would
Pardon?
that moot this issue?
Does
If he
it
goes
moot-
back to prison, would the determination that the statute doesn't apply to parolees be moot because he's no longer a parolee?
Well, I don't know that I want to say it moots because there's always a time factor. What if he goes back to prison while I'm arguing this and your decision comes down 6 months later and five months from now, for some reason, he gets released from the prison, he's out again. People may bounce back and forth. That's why I think we need to have something, we can't just rely on that.
Something definitive for him and everybody else. Okay.
That's what I
Counsel,
have.
you made reference, I believe, in your argument to 21, 25, 12, subsection A, but then you also said the language there in your argument was further supported by FB, small
Yes.
double I, is that correct?
F2B, I think it's F2B.
Oh,
two small
F2,
Is.
capital letter B, I.
And would you mind repeating for me how you think that language in that subparagraph supports your position?
Yes, that language, I have it right here. States, I'll go back up, 2 states, if the results of DNA testing conducted under the section are favorable to the petitioner. I've got the updated version here. In other words, if the testing is favorable to the petitioner, it states 4 things that the district court then may do, including but not limited to in order: 1, vacating and setting aside the judgment; 2, discharging the petitioner if the petitioner is in custody; 3, resentencing the petitioner; or 4, granting a new trial. So I focus on 2. The court, if it finds favorable DNA testing, may enter an order discharging the petitioner if the petitioner is in custody.
So
To
you're
me, that
saying
means
that's
if-
just,
if-
I'm sorry, you're saying that that's just a repeat of the language in A, which is a person in custody, not necessarily incarcerated. Is that your point?
My point being that the legislature anticipated that someone might not be in custody, and in custody, I still think in custody means on parole, prison, probation, bond, any of those things are in custody. And I think they anticipated, I interpret it as anticipating that a person may actually be done with their parole, probation, bond, and completely out of prison. And yet they still have the right to have this decision made by the court.
It's a reinforcement, as I understand it, of your point based on the language found in subparagraph A. Is that correct?
Yes, Judge.
All right, thank you.
Well, Art, doesn't, it also seems that the if in custody implies that they may, by the point of the court's order, no longer be in custody. Is that your point?
That's my point. Yes.
That's what I understood, so that there's that indication that something may have happened, it almost seems as if it keys us back to the time of the petition filing, perhaps, is the point where custody is important.
Well, to my mind, I want it to mean that the legislature thought this through and determined that someone might be in prison when they file that petition, as Cheeks was, and then they're either out of prison, or I would like to say completed parole, and then as a relief, the court may discharge that person. So I think it supports my argument. I think it anticipates that somebody just might not be in custody when the district court makes this decision. So I don't think it changes the fact that at the time of filing you have to be in custody. But so I think the legislature is anticipating there's some kind of change in status between the time of filing and when the district court makes its decision. In this case, there has not been any change in status. He was in prison in custody. He's now in parole in state custody.
But he did change, just so I'm clear, he did change his actual status in terms of in prison versus on parole from the time he filed to the time the district court ruled.
Absolutely.
So when he petitioned, in the language of the statute, he was actually in prison.
He was in prison at the Lansing State Penitentiary, yes. He filed it pro se.
Any more questions? Thank you, counsel.
Thank you.
May it please the court, this is obviously a case of statutory construction. The legislature, in creating 21-25-12, used simple language saying state custody is all it used. It had precedent before it when it created that statute. Now, if you go back and look at the purpose of that statute, was because DNA came about, was not available when a number of serious convictions had happened previous time. So they created a mechanism, a post-conviction mechanism for certain individuals to be able to challenge their innocence. The precedence that the legislature had was the two habeas statutes, 1507 and 1501. The language by the legislature in those was an expanded language. It didn't say in state custody. In 1507 it says a prisoner in custody under sentence of a court of general jurisdiction. And then in 1501 it says any person who is detained, confined, or restrained of liberty, ... physically present in this state.
I want to make sure I'm following this argument because I was struggling on this in the brief too. The language is more elaborate, but is it really more expansive of the right to bring an act, to bring a motion or file such a motion? It seems to me that the more language you have in each of those, the more restricted potentially.
Well, I didn't mean to argue it that way. I think
Okay, that's
I
what I
meant
was
to say
just
that it was
trying to
more.
understand.
It was more inclusive of who this applied to.
You think it's more inclusive in 1501 and 1507 than it is in 2512, or the opposite?
I think that 1507 and 1501 is more inclusive than 2512. And it's just based upon the purpose of the statute. This court's and the Court of Appeals' previous decisions, I think, have borne that out, that your interpretations of both 1507 and 1501 have obviously said that a person on parole and a person on probation both can have access to 1507 and 1501. Mm-hmm. Now, this court's decisions have even differentiated between 1507 and 1501 and said that they're not exactly the same for access, because 1501 requires being physically present in the state. So the state's argument basically is by using the simple language of state custody, they were referring to people that were physically incarcerated in the state to be able to have advantage of this tool to additionally prove their innocence.
And let me piggyback on your statement just now.
Okay.
Do you dispute that Mr. Cheeks was actually in prison at the time he petitioned?
His first petition, I do not dispute that.
Okay, so why do we even need to reach this question of whether probation counts as custody when the statute says a person in state custody may petition?
Because I believe that the purpose of the legislative intent was to allow this testing for someone who's wrongfully in prison, who's wrongfully sitting
Okay,
in a
but
jail
that's
cell.
not what it says. So are you conceding that the plain language of 2512 does not support your argument?
I don't know that there is plain language.
Well, it says a
Justice.
person in state custody may petition the court.
I agree and with what you say. However, it wasn't so plain language in 1507 and 1501. It's not clear by just reading the words on the page
Right.
there.
Right, but
that
you've
it
conceded that at the time he filed his petition, he was in state custody, even given your more limited definition, right?
Correct, yeah.
So again, my question is, how do we even reach the question that you want us to reach, which is probation doesn't count?
Because at this point, at the point in time that this came up again, after it was sent back by this court, he's no longer in state custody. And the purpose, I believe, of 2512 was to free those individuals that are sitting in jail cells that should not be sitting in jail
So
cells.
we do need to go back for you to prevail. Your argument is we need to go back and interpret this statute pursuant to a legislative intent that you've just described.
Yes, sir.
Okay.
That
Could
would
we-
be-
A purpose that we divine.
Could we, I'm sorry, I was going to ask a
Well,
question. Go ahead.
Let's talk about, if we're going to talk about purpose, let's talk about purpose.
Could
I
I
think-
ask a question about the statute before
Sure.
you go into purpose? We're talking about statutory interpretation. Do you place any significance upon the fact that in 60-1507, it not only talks about a prisoner in custody, but it also says claiming the right to be released versus that language not appearing in 2512?
I don't know. I hadn't thought about that, Justice Nuss. I don't know. I don't have that in front of me.
Could it
I'm
be
having trouble remembering that part of the statute.
Could it be suggested that in 1507, they are talking about somebody, based on the language, who's actually incarcerated? And because they did not put claiming the right to be released in 2512, that it means somebody has already been released, e.g. upon parole, as this defendant is. You follow me on there?
No, I'm not. Sorry. I'm having trouble.
Let
I'm
me
not
try
following
this.
you.
Let me go back to Justice Stiegel's approach. Is there anything in 2512 that specifically says it's limited to somebody who's claiming the right to be physically released from incarceration?
The language used by the legislature doesn't explicitly state that. No.
All right,
I'll give you
thank
that.
All right.
Okay, now,
I'm
if
sorry.
we may, I think when you first stood up, you said the purpose of the statute, or she said it in the course of your remarks, that the purpose of the statute is to allow persons who were convicted of serious crimes, certain serious crimes, at a time when the science just had not advanced to the point that they might be able to demonstrate innocence by way of DNA, to have an opportunity to have evidence tested. And that's pretty self-evident, but I think there's plenty of legislative history probably. It's late enough in the day that we would be able to find some that supports that as well. So if it's about proving innocence, if that's what the purpose of the legislature was, then it's not just as simple as getting out of jail, is it? It's about proving innocence. And this has been recognized now. We don't go to those cases from other jurisdictions or the federal cases. We don't go to them if the statute's plain. But they do talk about that. They talk about the fact that there are adverse collateral consequences. Obviously, this gentleman apparently has had a tough time since he's been paroled and maybe going back to prison in Kansas because of other events since. So, I mean, there are restrictions that remain on a person who has not been shown to be innocent, as opposed to just having a reason to have their conviction reversed.
I follow exactly what you're saying, Justice Breyer, but I don't think I used the word proving innocence.
I thought you said to
believe-
have access to tools to prove their innocence. I thought I got it
Okay, I
down
hope I
correct.
didn't say that, because
Okay.
what I was trying to say is that if there's someone wrongfully convicted that's sitting in a Kansas jail cell, that they should have the right to get out,
Okay.
okay?
You think that,
Which I
that
think
the
is-
legislative purpose was limited to that it wasn't about letting people who are actually innocent have access to evidence that would demonstrate
I
it?
think it was restricted to, or meant to assist those that are sitting in a jail cell.
Okay, and do you have any particular legislative history or other information that we would consider in statutory construction that would demonstrate that point?
I don't have any specific language from the statutory or from the legislative history. I would refer back to Justice Rosen's dissent that he wrote in the previous Cheeks opinion, where he talks about it lies within the discretion of the legislature to decide how to allocate judicial and scientific resources, and the decision of the legislature to set limits on which crimes specifically qualify. So obviously that the legislature was thinking there are limits on this.
That's self-evident from the selection of crimes in the original. That's what the legislature was thinking. I'm just not sure it's self-evident from the words person in custody or in custody, especially given as that's been interpreted.
What-
interpreted
I don't
elsewhere.
think that the statute was meant as a, what I'll call a Project Innocence type statute. Project Innocence type statutes are meant for anybody who's been convicted. Instead, this was meant to release people from Kansas jail cells that are wrongfully in the Kansas jail cells.
Okay.
Why do you believe the legislature didn't have an intent to release them from the burdens of reporting on parole and the restrictions that are placed on them because of being supervised?
Basically because of the limited judicial, scientific, monetary resources, that it didn't intend to open that up to every person that's ever been convicted.
But do you have anything to point to for that? Other than just that's your view. There-
Well, I suppose I'm concurring with Justice Rosen in his view, in his dissent.
But I don't think his view says this is a line he doesn't draw lines like you're trying to draw a line.
I agree. No, I don't have any specific language that would refute or support that from the legislative intent.
Can you also address that language that Mr. Dent talked about at the very end with the question from the chief and myself about the custody, discharge if in custody? What does the if in custody qualifier mean if it doesn't reflect that there may have been somebody released from jail?
I'm going to answer it this way, I think, Justice Lukert, is that in this case, then, if he's not in custody, depending on how we interpret custody, then they can't discharge him. And my argument still goes back to then, if they can't discharge him, what's the purpose of the
But that's one of
2512?
That's one of four options for relief. It's not the exclusive option, and it just indicates that if still in custody, we'll discharge them.
But that's the only
Which
one
would
that
implies that if they're not still in custody, there's still other relief available.
I would just, I guess, suggest to the court that that was poorly worded when they got down to that part of the statute. That it wasn't given as much thought as the qualifying. Actually, that wasn't given much thought either when they just simply used the term state custody, which is why we're here today.
I don't understand why 223717 doesn't end this discussion. When the legislature says every inmate while on parole shall remain in the legal custody of the Secretary of Corrections and is subject to the orders of the Secretary. I mean, That's the legislature saying, if you're on parole, you're in legal custody of the secretary.
Which, I guess legal custody is not the same as state custody is my argument. And a good perfect
Based on
example.
what? I mean, but counsel, based on what?
Well, based upon our present circumstances. Okay, so he's in the legal custody of the state, but he's gone out and got himself arrested, and now he entered into a plea in middle of March sometimes to a federal felony crime. The state of Kansas DOC has issued a warrant for his arrest. I fail to see how that demonstrates control over him. They can't reach out and bring him back into prison. There's no control over him at this point in time. I think the recent, and that's why I filed that letter last night as I was preparing for this argument. I came across a letter from the Federal Probation and Parole, and I thought, what the world is this? And one thing led to another. I called counsel about 6 o'clock last night. So I guess all I'm saying is that demonstrates or takes it one step further that there is no state control over him.
He's
even
going
if
back to
he's-
prison if they have a parole hearing and he violated parole by committing the crime. So he's going back to prison because the state of Kansas will retain control to send him back to prison.
Maybe, Justice Johnson, he's going
But the whole point is he's subject to going back to prison. He's not a free man. He's subject to going back to prison because he's in the legal custody of the Secretary of Corrections, who's a representative of the state of Kansas. And I just can't understand your argument why the legal custody of the Secretary of Corrections is not state custody.
if we give it a liberal construction, I agree with you. I'm asking this court to not give
Not
it a
liberal, literal. It literally says he's in state custody. Substitutes the state of Kansas, the Secretary of Corrections for the state of Kansas, but the Secretary of Correction acts on behalf of the state of Kansas. Doesn't he or she do that?
It does do that. I agree. However, we've seen by the circumstances that they have no state control over him, and I don't believe the statute was meant to cover someone who's facing a long prison term in the federal system. That he should be able to take advantage of such a statute while he is under certain interpretations under state control, but he's not. I have no further argument to present to the court. If there's further questions.
Any more questions?
Just the practical situation. The practical situation is that you're fighting against having a DNA test done. I mean,
That's the
you're
bottom
not
line.
fighting against letting him out of prison or whatever. We're just, your objection is to the obtainment of evidence that could impact on whether he committed the crime. That's what we're talking about.
I'm fighting against the DNA test. Yes, sir.
And your position would be let his parole be revoked, let him be sent back to prison by the secretary, and then if he so chooses, he can file his post-conviction motion for DNA testing.
If that ever happens. And I say that because he's 54 years old. He is going to have a maximum 10-year sentence in the federal system. We may never see him in Kansas again.
All right. Thank you, counsel.
Okay, thank you.
You reserve 3 minutes for rebuttal.
Thank you. Just very briefly. The fact that my client is not in a Kansas jail cell, or the fact that he's in Missouri, I don't think affects what this court should decide. Actually, if you look at page 10 of the appellee's brief, Maggard versus State, this court, the Court of Appeals quoted, "We interpret 60-1507 as permitting an inmate to bring a habeas corpus claim under this statute if the the inmate is in custody, whether in Kansas or elsewhere. So obviously and I've had clients who are in Colorado, but they still file a 60-1507 concerning their Kansas conviction. The fact that this person is in Missouri or has pled but not sentenced to a federal offense doesn't change his status with the state of Kansas, which meaning he has this lifetime sentence in Kansas hanging over his head. I just can't imagine why the legislature would want to distinguish between someone who's in prison and someone who the next day was released and is on parole. For instance, if, it's hypothetical, but if Mr. Cheeks was still in prison today, or actually I guess I should say on the day that the court, let's say the day before the court heard the motion, he was in prison, and then the day that the court heard the motion, he was released on parole. I just don't think the time-wise it should matter. You're in state custody either way throughout the entire process. So I don't have anything else unless there are other questions.
Any more questions? Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement this time.